Strict liability. Strict liability. The rule of strict liability. The rule of Rylands versus Fletcher. Strict liability. A person may be liable for some harm even though he is not negligent in the same or doesn't intentionally cause it or is careful or has taken steps to prevent the same. The defendant is liable to the neighbor for emission of harmful gases with offensive smell from his big or melting furnace, or constructing a dam which diverted water from its natural channel on the land of neighbor. Such liability is called strict liability. Facts of the case. Plaintiff owned and operated a mine adjacent to which defendant constructed an artificial reservoir. The latter caused a mine shaft collapse, which resulted in a flood and damaged plaintiff's operations. The plaintiff sued. The matter was brought before an arbitrator to independently establish fact. The trial court found for plaintiff. The appellate court affirmed. Defendant appealed to the House of Lords, which also affirmed. Judgment. Justice Blackburn gave the rule of strict liability. The person who, for his own purpose, brings on his land and collects and keeps there anything likely to do mischief if it escapes, must keep it at his peril, and if he does not prima facie answerable for all damage which is the natural consequence of its escape. Rylands was not satisfied with this decision and appealed in House of Lords, and the appeal was again overruled by Lord Grains. He agreed to the decision of Justice Blackburn and added a condition that the land from which escape has occurred must have been used in a non-natural, inappropriate or unusual manner. Essentials. 1. Some inherently dangerous thing must have been brought by the person on his hand. 2. That thing must escape from the land. 3. It must be a non-natural use of land. Dangerous thing. Thing which has been escaped must be dangerous. A thing may be dangerous by itself or it may not be so dangerous, but due to its nature, contents, quantity used may be dangerous. Escape. Thing which is brought on the land must escape, which means, escape to the area outside the occupation and control of the defendant. Some examples of escape are 1. Water flow, Rylands versus Fletcher. 2. Protruding branches of trees, Crowhurst versus Amersham Burial Board. 3. Escape of dangerous animals. 4. Escape of gas fumes. Non-natural use. It is difficult to decide what is natural use and what is non-natural use of land. From following examples it will be clear. Non-natural use. To collect a large heap of colliery soil upon unstable land. To accumulate gas in large quantity in pipe. Overuse of power. Huge quantity of water fumes. Planting poisonous plants. Loaded gun. Exceptions. 1. Act of God. 2. Act of third party. 3. Plaintiff's 1 fault. 4. Statutory authority. 5. Consent of the plaintiff. Act of God. Act of God is a direct, sudden, irresistible, violent act of nature as could not by any amount of foresight have been foreseen, or if foreseen could not by any amount of human care and skill have been resisted. Example: storm, lightning, tempest, extraordinary fall of rain, extraordinary high tide, extraordinary severe frost. Act of third party. If the defendant is taking reasonable care and is maintaining it with the utmost care, and if the escape of the dangerous substance is due to a wrongful act, third party or stranger, then the rule does not apply. The plaintiff cannot claim for damages where the act is done by a stranger. One who is neither defendant's servant nor the defendant has any control over him. Plaintiff's own fault. Plaintiff's own fault is another exception to the rule of Rylands versus Fletcher. If the damage has been done by the act of plaintiff himself, then the rule does not hold. The plaintiff cannot claim for damages for his own wrongful act. In Ponting versus Noakes, the plaintiff horse nibbled some poisonous tree by crossing the defendant's boundary and died. It was held that the defendant is not liable. No escape of dangerous substance. Statutory authority. If the act is done under state's authority, then defendant cannot be held liable. No action will lie against the act which has been authorized by the legislature, if it is done without negligence. Consent of the plaintiff. If the plaintiff has directly or impliedly consented to the presence of the source of danger and there has been no negligence on the part of defendant, the defendant is not liable. The plaintiff cannot claim for damages if the plaintiff has consented to the presence of dangerous things. Law of torts in India is based on English law of torts. In India, rule in Rylands versus Fletcher is followed along with its exceptions. Visit our website, www.orionlegalassociates.com. Orion Legal Associates. Coach in 18. Thank you for watching video. Please subscribe channel for further updates and press bell icon for last updates.